A warning. This podcast is for informational purposes only and should not be considered a substitute for legal advice. And if you have a question or wish to act upon the information in this podcast, we recommend you consult an attorney in your particular state. Welcome back to Punk Law 101, everybody. It is I, as Walter. We are here back on the Punk Law 101 podcast. We will be joined shortly by Mr. John Rinaldi. Today, we're going to talk about a couple of Supreme Court opinions that came out, one dealing with the gas pipeline, one dealing with complete ineptitude of an attorney on a death row death row defendant, and also the recent employment law decision dealing with the LGBT community, because that Gorsuch wrote that opinion, and me and John are going to talk about that. Also, the Supreme Court denied hearing the qualified immunity with police officers. They aren't going to take up a case on that this next session, and they also are not taking up a case on ICE, right? And we'll talk a bit about that going into this episode. So let's welcome back on my buddy, our friend, Mr. John Rinaldi of Legal Aid in Newark, New Jersey. And welcome back to Punk Law 101. I'm Walter, and we are here with Mr. John Rinaldi.
In New Jersey.
Yeah, there's a lot of stuff that happened this week. Yeah, the lawyers in New Jersey part, that there should have been like some kind of particular like snapshot of that, like, oh, New Jersey lawyers specifically. But a lot of the stuff we're talking about is applicable to more than just being New Jersey or New York lawyers.
Well, I mean, given the topic of Supreme Court, it's applicable to everyone.
That is true. So yeah, we're talking today about the Supreme Court decisions that came out. A couple of the stuff that they denied hearing, but also three of the opinions that came out yesterday. There's going to be more coming out on Thursday, right? So we'll hear more about that.
I was going to say to you before we started rolling, like, it's not over yet.
No, it's a good thing, but that's a good thing to get like chances to break things down. And, once we hear more of the stuff that comes out on Thursday, we'll have another episode out for that one.
I do appreciate that they kind of put the big splashy one out first.
Yeah. So yeah, let's talk about that. Bostock versus Clayton County, Georgia, and that was a big deal. Everybody was talking about it, man. That was the you cannot be fired for being gay or trans in your employment. They basically interpreted the federal Civil Rights Act, Title VII, and said, listen, it says you can't discriminate on the basis of sex. We interpret that as being including of gender identity.
I mean, I think what got people was that it was a 6-3, given the conservative makeup of the court. But in fairness, I was not surprised by this. I had a very strong feeling that it was going to come down to a 6-3, maybe a 5-4. My reasoning for that being is, like, Gorsuch had actually written an opinion in the D.C. circuit that was kind of along those lines. So I'm like, well, Gorsuch is probably good for that. And as I said to you a million times, I think because it's Robert's court, he cares way too much about how history is going to look at him. And I don't think he would have wanted his name on that, on a dissent anyway.
Not only that, he gets the fact that he was a part of that opinion, he got to choose who wrote the opinion.
Yeah, but I don't know that I don't know that they gained any real advantage. Gorsuch was pretty thorough in that opinion.
And it relied a lot on something that a lot of conservatives like to talk about, which is textualism. And my favorite was Ben Shapiro's rant on Twitter. I think I sent you to that. Oh my God.
I remember people were putting up the tweet that Ben Shapiro put up back in 2017 saying that Gorsuch is going to be a great conservative pick. That didn't play out too well for you there, did it?
I mean, it depends on your definition of conservative in this regard.
That's true, but let's be real. What Ben Shapiro's opinion of conservative is. It didn't work out for him.
I think that's the mistake that most people have, is that they look at conservative like political conservative, and that there is a broad spectrum, especially for Supreme Court justices, how they could interpret the law. You might have a judge that you interpret as being conservative, but but for instance, in this case, Gorsuch is conservative, but he's more of a textualist, originalist conservative. But he interpreted something that he pointed out. The thing that is big about this is that he focused extremely on the text, which was, you guys mentioned sex, and then he kind of went, but for. Oh, they kind of added the but for test in there.
He went very deep into how but for causes work.
If you're going to go ahead and fire somebody who is trans, you're basically firing them on the basis of sex. If you're firing somebody who's gay, you're firing them for something that if they were in the other, if they were born the other sex, you wouldn't be firing them for.
The nuance that I took from it was, what he was saying was, you can fire someone for, okay, how should I put this? Because like the way that he worded it was like, you could technically fire someone for being gay or trans, but the moment that you do, you must take sex into account. I think he's like making that very nuanced argument of, it's not the fact that you fired them for being homosexual. It's the fact that you did it, but in order to even find out, in order for you to find out someone is homosexual or trans, you then have to know what their original sex was. That I guess under a veil of ignorance, you could do it, but that's like not a tenable. So like, you can't really do that in real life.
Yeah,
it was extremely nuanced. It was to me, it was an almost tortured point. Like, you didn't have to make that point, but I understand what you're saying.
Which I think is why Roberts wanted him to write the opinion and not, like, say Gorsuch say it was a 5-4 opinion. It would have been Ginsburg deciding who wrote the opinion.
See, but like,
and it could have been.
I still don't believe that Roberts would have wanted his name on that dissent. I really don't think he would have wanted that. This is the Roberts court. Does he really want, 30, 40 years from now to people to look back and be like, yeah, the Chief Justice was against civil rights?
Well, he was against Obergefell, wasn't he? He was on the dissent on that. Yeah, he was on the dissent on that.
Yeah, but he wasn't the Chief Justice then.
Wasn't he?
I don't think he was. Didn't Kennedy retire shortly after?
Well, Kennedy wasn't
crap! I'm getting my justices mixed up. Who was the Chief Justice?
The one before Roberts, I think, was it Rehnquist?
Not Rehnquist. I don't know. I get them. No,
because we were talking about so basically they outlawed discrimination in the workplace here, and let's see. The thing that is, there's two things that we were talking about before we started rolling, was the effect on other laws and how they're going to be interpreted with this, because it's very specific what they focused on, which was sex, and things like the Fair Housing Act, which was amended in 1974 to include discrimination on the basis of sex, and there's 24 states that don't interpret it to include LGBTQ people. Like, now you might get interpretations of that more broadly across the country.
I mean, I'm certain that this is going to have like some cascading effects on that type of thing. I just, to me, the biggest thing that sticks out in my mind is that Trump changing all the health regulations to let doctors discriminate against trans individuals probably isn't going to survive now, given this ruling. I don't know how you could square the two.
We have to stand the Rutgers people who are involved in this. So apparently Katie Iyer is a law professor at Rutgers.
Oh, I did not know that. Well,
she co-authored the amicus brief on behalf of the Scholars Statutory Interpretation and Equity Law.
Oh, I was
arguing
unaware.
the textualism element to it. So that was requiring the favor in front. So even that was.
One of the things that I like so much was that people were going, like some more conservative pundits were like, oh, well, it shouldn't just be textualism. What about Congress's intent? I'm like, well, you can't have both. you can't pick one. It reinforces to me that it's textualism when it's beneficial to us.
Yeah.
And congressional intent when that's beneficial.
Well, that was something we discussed earlier, which was before we got on, was that just because you wrote it a certain way, we see this with laws all the time where they are written a certain way, but because they are written badly or they are written not with they are written and then they go out into the world and judges interpret them, it left it up to open interpretation as to what would be discrimination on the basis of sex. So just because that wasn't what they intended doesn't mean that's how it ended up being.
I did kind of like in the opinion, Gorsuch kind of like slaps that down with, we only look to congressional intent when it's ambiguous, and there is no ambiguity here. Like, oh, that's that may not sound like a slap down, but that was in judicial language.
Oh yeah, I mean that's 100% true though. Like that's if you have a clear way of interpreting it, and this I honestly think Gorsuch's way of interpreting it is the correct way. It's very clear. It again like it's almost kind of so straightforward. You're kind of asking why are we litigating this, but because that wasn't the intention 30 years ago.
I mean, and like the argument that people were making was like, fine, you want to take congressional intent into consideration. Why don't we revisit Heller? And let's look at congressional intent when the Second Amendment was written.
Yeah.
Like, you can't be a textualist for the Second Amendment and then scream about congressional intent everywhere else. Like that's just not, you can't do that.
Oh yeah, well that brings up the whole what's it called, the whole BS around textualism and originalism to begin with, which is
many feelings about this.
People who claim they are originalists when it works for them, and
exactly.
then so that's always kind of the problem with them.
I have yet to meet an originalist who like doesn't make excuses for things that they want,
like Citizens United.
Exactly.
Like that went against 200 years of precedent. Same thing with what you're saying with Heller. It's.
I mean, no, do our listeners know what Heller is? They might not.
Yeah. Well, it's the Second Amendment, right? It was Scalia's favorite. It was like that's one of the ones that people point out to as far as Scalia, not being an originalist.
Yeah, and that's always the thing that I bring up is like, well, okay, you're an originalist until it's inconvenient. Like Scalia did it; he literally did that, and it's like I don't understand how you can have that position, or at least not in good, at least in good faith anyway. Like, how can you in good faith say you're an originalist? And then, like, let's be fair, originalism is kind of stupid because it implies that Congress at the time of the Constitution was written was able to look forward and anticipate every possible issue that could ever arise, and if they couldn't imagine it, we just, oh well.
I think it's even. I think it's just dumb in the regards to, like, with originalism, there's nobody who's not a textualist. There's nobody who looks at a law and it just ignores what was written on the page. Like when you're interpreting something like that, you are, you do need the text to be involved. So the people who complain about it, the originalists who sit there and complain about it, like there's nobody who doesn't do that part of it, but there's more to it.
I mean, to me, the real question is like, give me the originalist, opinion on like the internet. Like, tell me what would the founding fathers have done with that? They wouldn't know, and so we have to have judges interpret the laws that were written and kind of work them into the modern understanding of the world. It creates a worldview that is just completely untenable.
Yeah, I don't know. I think people make too much of a big deal of I'm an originalist, and that's all they just determine themselves to be, and they think that's the one.
Stupid.
Yeah. The other major thing that we were talking about before was that there was basically this giant gap in Oberfell. Like after Oberfell was decided, you're talking about now 5 years ago, where people could get married, and you can't fire them for being married, but you could fire them for being gay. Like in the amount of states that's still like previous to this decision where they didn't have a law against discrimination on the basis of gender identity.
I mean, my guess is it just takes years for these cases to work their way through the courts. So like when was this lawsuit even filed? I'm sure it had to be years ago.
Let's see if I can pull that up.
Like, because like the first filing was probably like 3, maybe 4 years ago. Because like working your way through the circuit courts takes forever.
Yeah, well, I'm just saying it left this weird gap in the law. So
Well,
people
yeah.
who before this was decided, you had 5 years of, again, you can't fire somebody on the basis of who they're married to, and you can't fire, but you could still fire them for being gay. So there's this weird thing going on. It's like you can be dating somebody and you couldn't tell anybody you worked with.
I think my point being is like the court probably knew this was a gap, but they
Yeah,
had
and
to
they were,
wait for the question to come up because they couldn't really slip that in to
no, you
like
couldn't do that.
you can't do that. You just kind of have to wait for it to happen. And like, well, there's a gap in the law for a couple of years until this case works its way up to the Supreme Court.
And that's the other thing about law is that you need a case in order to decide something. It also might be like we were talking before, and actually we didn't bring it up, but there was also a couple of denials for cases as far as what they might hear next term. One of them was the qualified immunity case. And
Yeah,
that might be one of those things where they sat there and said, maybe this case isn't what we want to work with this on. Maybe they're waiting for a better case to come down the pike, kind of
that
deal.
could be it. Or like it could be that they just think that like states need to do this.
States or Congress needs to go ahead and get
Yeah, like
rid of this.
I wouldn't be surprised if they're kind of passing the buck on this and say, you guys figure it out.
Yeah, I get that. It was just funny because like you had mentioned like a week or two ago, like, oh, Clarence Thomas was like interested in revisiting it, and I guess nobody else on the Supreme Court was.
Yeah, but see, that's why I think there has to be some sort of like scheming going on because like we've said before, you only need 4 justices to hear a case,
Yeah,
and if you're telling me that the 4 liberal justices plus Thomas said no, there's got to be a reason for that.
and part of that might be the idea of like bad cases make bad law. Like you might have a case that comes up, and it either fits perfectly with what you already established, and you are either overturning precedent, and is there a way to find a way of revisiting it that gives you a good case to base this on. So
Yeah, because I think there are 4 justices on the court who would want to hear this,
I definitely
but
think there's
but
some justices on the court that don't, though.
well that's true too, but I think they're in the minority on this one. And
Like
actually,
I could see Roberts not wanting to hear it
perhaps.
because that means you're turning over years of precedent, and
I
there's a
mean, but the thing is, though, you're turning over what is probably a bad precedent, which is
oh
like
no, yeah,
that's fine. Like you can do that. Like they're like big cases overturn bad precedent. That's fine. No one's gonna look at you unfavorably for like. I don't know. There has to be something going on behind the scenes there. There just
well,
has to.
like for instance, Loving versus Virginia, like, and they just celebrated like 53 years of that the other day.
Yeah, and like no one's mad about that. I mean, I'm sure maybe there are some people that are mad about that.
But I think that was a case where they decided to take a very specific case to go ahead and apply a better law. Where they sat there and looked at the case where it was like I think that was, hey, we're going to pick a palatable case, we're going to fight, we're going to win this one, and it made it all the way to the Supreme Court and they won.
I mean,
Whereas I think this is one of those cases where again it depends on what case is on the table too.
yeah, I mean that's the yeah. Like I don't think he would say no to it because he's afraid of it. There has to be some reason that like we are not privy to, where he's just like this is not the right case or this is not the right time.
Yeah. And well, it also could be that hey, it's going to look like we're being swayed by public opinion.
I mean, but like, so what?
I mean, it's happened before. We've seen it in the slaughterhouse cases where actually public opinion did kind of sway.
Yeah, like I mean, I don't see. I think the argument in my head is if you are doing what you believe is being on the right side of history, then like whatever. No one is like mad at the court for like Brown v. Board of Ed. No one's again. Maybe some people are mad about that, but when when you're doing things that are big social changes that are aligned with public opinion, I don't really see the problem. Like, so what if you were swayed by public opinion? that
I
matters.
think it depends on the justice how they feel about it. I think Roberts would not be a big fan of that. I think some of the other ones might be interested in that, specifically Ginsburg and Breyer. I think though they would probably be and and Sotomayor, who by the way, one of the cases that bringing up her dissent in one of the cases is actually pretty good.
Which one was that? I got the cases mixed up in my head. Which one did you? Was that
United States Forest Service versus
Yeah, I thought it was the pipeline one. That's right.
yeah, that's a dude. By the way, that opinion's so complicated.
I was gonna say that's a case where like people are like making hot takes about it, and it's like it's so much more complex than that.
They're looking over like 3 different statutes, and is it an easement? And we'll touch on that one sec. Let's talk about the one other case that was denied, which was the ICE case. That was the Ninth Circuit, based in Stanford. Basically, what happened is San Francisco sheriff said that I don't want to go ahead, and they basically came up with a policy. The new policy was that illegal immigrants arrested for petty crimes won't be held in jail longer than necessary. And even if the U.S. immigration agents may want them detained for possible deportation, they still wouldn't keep them. Instead, starting like the Wednesday that they were going to do it, deputies will treat the eligible people for release like U.S. citizens. They'll be cited to appear in court. And this policy was an attempt to basically comply with the sanctuary city thing that San Francisco was doing. And
I mean,
he said, and basically the sheriff was like, listen, I'm in a weird position. They want to do this sanctuary city thing. I'm trying to enforce the local law and not violate federal law, and this is the way we could do it.
Yeah, I mean, at the end of the day, I think what happened here was that the court declined to hear it simply because they weren't like the Trump administration was going to lose, and they're just like, we're just not going to bother.
Well,
we don't need to reaffirm this. There is established law, whatever.
Yeah, the Ninth Circuit Court of Appeals said that the sheriff didn't have to enforce the federal law, and basically said San Francisco local officials had no duty to help immigration agents enforce federal law. And we have a case like this. It's called Prince versus U.S., which was established. It's not even that old of a case.
Yeah, I was gonna say it's relatively recent, wasn't it?
It's like 25 years ago. It's like, in my head, a 25-year-old case being the precedent that we're talking about.
I said relatively recent.
Yeah. Well, it's older than Oberfell. So,
well, I mean, yes, but it's not older than us.
Yeah. That's a shocker when we're talking about cases being like this major press. But yeah, it's like in the last like 20, 30 years. And basically, established that the federal government can't basically force the state government's policing agencies to carry out their laws under the necessary and proper clause. Yeah. And I think that was a 5-4 decision that had a lot of its own kind of complications to it.
I think what happened here, like part of it was in my head that they declined to take it, not only just because of that, but because the conservative justices could have said, no, we want to take this, but probably realized they didn't have a majority and were like, well, let's not because if they had agreed to take it and then if they lose, well, now it's been reaffirmed by the Supreme Court. Let's just leave it with the circuits, and if the circuits want to split, the circuits can split.
And usually,
they probably won't. Frankly, I shouldn't say that. Maybe they will.
Well, usually when we see a case like this, it means that the lower court got it right.
Yeah, I mean, again, it's like it's implied that the other circuits are going to look at the Ninth Circuit and say, well, they got it right. That's a pretty persuasive argument. Because what are you going to do? You're going to go to a judge in another circuit and say, well, the Supreme Court had a chance to say that they were wrong, and they didn't. So you would imply that they were right, but I mean, they're not bound by that. There could still be a circuit split and force the Supreme Court's hand, but that's not going to happen anytime soon, apparently.
What was shocking with that one was Clarence Thomas and Alito both said they actually were interested in taking that case.
Of course they were, because we know how they would have voted.
Well, that's weird because wasn't Clarence? I felt like Clarence Thomas was one of the ones who voted on the Prince case and voted the other direction. So I'm like, But again, a part of it sometimes is just.
But remember, this is also, I will vote for this when it is when it is convenient for me, and I will vote against it when it's not what I want.
Yeah.
I think I said this. Well, I might be echoing because I walked in the kitchen to grab another beer. But I think I said this on one of the other episodes. Clarence Thomas is the biggest Uncle Tom to have ever lived. I'm sorry. I have no respect for the man whatsoever.
It's just going to be your log line every time. Every episode.
I can make that my catchphrase. No, because I was going to rant about this for a quick second. He had the nerve to vote no on gay marriage when he himself is married to a white woman, and his marriage would have been illegal under the for the exact same justifications 50 years prior. Fuck you. You don't get to do that. Oh, I'm allowed to have interracial marriage, but you can't have gay marriage. Anyway, fuck him, Uncle Tom. I'm done.
All right, so let's talk about one of the other two cases. There was we talked about the pipeline case, which again this is a much more complicated one, and basically it was funny because if you read Sotomayor's dissent in this, she goes like, yeah, they focused on a lot of very complicated concepts like easements and things like, and she goes like, it didn't need to be this complicated.
Yeah.
It was a very complicated discussion of private law easements, footpath maintenance, differently worded statutes, and policy masks simply and it masked the dispute that's going on, which was
actually real quick. If we're talking about dissent, can we very briefly touch on Alito's dissent because it just reeked of salt.
Oh, on yes.
All I have to say about it is this: Alito is not Scalia. He cannot write a scathing dissent and make it entertaining. He just seemed mad. Scalia's dissents, like, they were funny. I disagreed with them, but they were funny. Alito was just mad. I'm like, oh, dude, like.
Yeah, he echoed the same thing. The problem is that Alito and Thomas have no direction without Scalia.
I know. I feel like literally the head of the snake has been cut off and the body is just withering. Because let's be real, Thomas was kind of just Scalia's lackey.
And Alito wasn't much better either. Like,
no, I mean, yeah, but I feel like it was less apparent. Yeah. But the both of them just did whatever Scalia wanted, and like now that he's gone, oh.
And Kavanaugh's basically just Alito 2.0.
I don't even know if that's true though.
Yeah.
It's too early to know. Yeah. It's too early to know.
Yeah, we need to see more opinions from him. The reason why I was thinking is kind of just how he joined in on this opinion, and
yeah, that was surprising to me too. I don't know.
Basically, what happened with United States Forest, which was the gas pipeline case, is that you have this piece of land, and there was some dispute as to who's in charge of it and what it was called, right? Is it an easement that's controlled by the Appalachian, it's called the Appalachian National Scenic Trail, which is like, is it part of the park system? Does it fall under the Mineral Leasing Act? And the Mineral Leasing Act authorizes the Secretary of the Interior to grant rights away for natural gas pipelines through any federal lands, but it particularly excludes the national park system. So the real question is this piece of land that we're talking about here part of the national park system? And it goes over who's controlling it. At one point it was it the organic? They go over 4 different acts, by the way. It's like you really do need like a diagram of like some of this stuff.
I can feel the eyes of the people who will listen to this in the future glazing over.
Yeah, it's basically they focus on a thing called easements, which is weirdly like, why are you talking about an easement in this? Where it's like it's all public land.
Class.
Yeah. like I said, I liked the way Sotomayor wrote her opinion because it basically walked everybody through. Now, granted, her opinion was the dissenting opinion. Basically, what ended up happening is that they ruled that the Secretary of the Interior, he can assign his ability to grant leases on pieces of federal property to other members, including the Park Service. So basically, the question was whether he had that authority to do it. Which, because here they were giving a lease to a company to put the gas pipeline in underneath it.
It's very complex and has to do with land use.
Has to do with land use, has to do with what agency is really in charge of this piece of property, and whether they had the right to assign, give a lease to this piece of property, and whether it was considered part of the park system or is it just federal land. So, and the court held that they were eligible to grant this land right to. They were able to grant the lease to the company, which even Ginsburg joined in on the.
Yeah, I was gonna say people should
side.
like cut Ginsburg a little slack here. This is not this was a very complex case, and like I understand the why. I may not like the outcome, but I get it.
I kind of disagree with Sotomayor on this. I think that she walked it through very perfectly, and it was like she walked through who had control over this piece of property and whether it's considered an easement. Well, listen, it's a piece of land. It's under the park system. They treated it as a unit of the park system. But yeah, it's a complicated case. Yeah, I just wanted to touch on it. I don't think we should spend 20 minutes on this one because I don't
think people really want to know about like the finer points of like federal land use.
I do think so. There were a lot of people who were upset about it though, and they were upset about Ginsburg, like you had mentioned.
Yeah, I think it's a case where I think it's a case where emotions run high, but the actual like mechanics of the case are not that interesting.
Yeah, it's kind of like bankruptcy, which like it's the mechanics of it are not sexy. Just it's foreshadowing. That's what the point of that was. It's not the mechanics of it are not sexy, but the 50-mile high view might be a little bit interesting to some people. Where it's like, yeah. So let's move on because I think this is gonna
a bit of a downer.
Yeah, it's gas pipelines going in. Sorry, folks. That's the downside of it. There's a gas pipeline going in. Maybe people will protest it and fight back, and who knows?
Who knows? Maybe they'll burn this pipeline like they did that other one.
Yeah. So, okay, let's talk about the last one that came out this week was the Terrence Tremaine ANDRUS case versus Texas. And basically this guy had attempted a carjacking, and I believe somebody died in the process of this. He had to have died because it's a death penalty case.
I mean, it's Texas. They give you the death penalty for anything, so.
But this was actually a ineffective assistance of counsel case. So basically, we're basically saying his attorney sucked dick. His attorney sucked so much, and not for nothing. Reading this case, it made sense why even the court, even the Supreme Court was like, you guys kind of fucked up. This guy fucked up bad.
The crazy part is, it's like how you have to fuck up really hard in order for an ineffective assistance of counsel thing to happen. You have to you almost have to try on purpose. I don't understand. I really don't. Like, how did you fuck up that hard, man?
But this is actually sexier than the gas pipeline case, right? This guy
it is, but
unsuccessfully attempted a carjacking. He was under the influence of PCP-laced marijuana. And after the bungled attempt, he fired multiple shots, killing the car owner and a bystander, and the state charged him with capital murder. And during the guilt phase of the trial, defense counsel declined to present an opening statement. After the state rested its case, he immediately rested as well. And hang on, there's more to it.
So he did nothing?
He does even less. Hang on. He does less. In his closing statement, defense counsel conceded his guilt and informed the jury that the trial would boil down to the punishment phase.
That's like comical level of
Well, okay,
Fuck.
I understand that there is a basis for this. This might not be totally, especially for states where you have a capital punishment state where you do have two different trials. You have both the trial for guilt and then you have the trial for the death penalty,
I mean,
which is
but you
what
have
they
to
do in Texas.
try, though.
So, so basically, what he's saying is, listen, I can't win the first case, right? I just think that the evidence is too far out there. There wasn't anything I could provide as far as the first phase of this. Okay, maybe you have an argument to that. Punishment phase, right?
Ugh.
Hang on, I'm saying maybe, but we go to the punishment phase. Dude, he doesn't do much here either. Once again, he presented no opening statement.
What the fuck?
In his 3-day case, the state put forth evidence that Andreas had displayed aggressive and hostile behavior in a juvenile detention center. He made no material objection to the state's evidence as far as to his tattoos being gang affiliated, that Andreas had hit and kicked and thrown out of prison officials while he was waiting trial. When the defense had to do their case as far as mitigation goes, he had called Andreas's mother to testify, but he had never met with her.
What? This person
Up
did not
until
try.
this point.
No. I understand being in the position of my client probably fucking did it, and there's not much I can do. But the problem isn't that you lost. The problem is you didn't try.
Yeah. So there's even more to this. Hang on.
There's a minimum level that you have to attempt. Otherwise, you should be disbarred. I'm sorry.
The direct examination of the mother, right, focused on biographical information and did not reveal any difficult circumstances in Andreas's childhood. Meanwhile, it comes out later on, and even, by the way, this shows how little he knew his client. His client had a horrible childhood. He was like one of like 7 kids. His mother could not take care of him. In fact, when he met with one of the experts on the case, the expert was saying, like, I think she, actually she took the mother took a $10,000 policy out on Andreas that if he had been executed, she gets to collect on. And
you can't make this up.
This is why I wanted to go into some of the facts on
this. What the fuck?
This is why I wanted to go into some of the facts on
you
this
didn't
one,
bring this up in questioning?
Nah.
I would have brought that up in questioning. Just make the jury feel something for this guy so you don't kill him.
His second witness was the biological father with whom Andreas had lived with. That guy had been in jail for a bit. So now you're almost establishing, almost like psychologically to the jury and to the judge that, hey, this guy is a long line of criminal offenders.
Man, I'm sorry. For me, the moment where if I'm on that jury, I'm like, all right, maybe we shouldn't kill him, is the moment that his mom took out a life insurance policy on him.
They didn't know. That part was not known to the jury at the time.
That is beyond. That's, oh my God, I didn't even know you could do that.
By the way, so initially he was going to just put up the dad and the mom, and once the dad stepped down, he was going to arrest the case. Then the court questioned him on it about his choice during a sidebar discussion, and then the counselor changed his mind and decided to call an additional witness.
Again, I understand knowing that you're not going to win, but at what point you're already there? You may as well try.
Keep in mind, one of these people is an expert witness, so he knew he had him as a potential witness.
I just don't understand what is the mentality of I'm not even going to try.
I don't know. This is why this is an ineffective assistance of counsel case.
You walk in there and I've had cases where like dude got caught with pot. Oh well, there's really not much we could do about it. But I didn't go, well, frankly, Your Honor, he did it and you should throw the book at him. Like, no, that's not what you do. You try. You make the argument, and then the judge can tell you that your argument's bad, and then, well, you tried. Like, what more do you want me to do?
So yeah,
I truly hope this attorney got sanctioned. That's
that's
beyond.
It gets worse. It continues to get worse.
How could it possibly get worse?
So he then calls Dr. John Roach, who's his expert witness, who he wasn't originally going to call when he rested, right?
Mm-hmm.
Then he focuses only on the general effects of drug use on developing adolescent brains. I didn't really pull enough testimony out of the mother. Had not called Andreas himself to testify yet. And by the way, the state quizzed Dr. Roach on his relevance and purpose of his testimony, probing as to whether why he drove 3 hours to tell the jury that people change their behavior when they use drugs. So, and actually Roach later on testifies in the habeas hearing as to the attorney's ineffective assistance of counsel. The next witness was a prison counselor who would work with Andrus and started having testify that he had remorse the past 2 months and was making progress. All right, that showed he was kind of like he might be getting better. That might provide a little bit of mitigation, but not a lot. And then he finally had Andrus testify, and he contradicted his mother's depiction of his upbringing, stated that he had his mother was selling drugs when he was a kid, when he was around 6 years old, and that he and his siblings were often home alone when they were growing up. His first time using drugs was when he was 15, and they spent there's 4 pages of the transcript talking about his childhood. So after this whole thing, they sentenced him to death. Unsuccessfully appealed, and
what appellate court didn't see a problem with that?
Then he filed a habeas application. For ineffective for failing to, basically saying his attorney was ineffective and failing to investigate or present available mitigation evidence. During an 8-day evidentiary hearing, the Texas trial court categorized it as a tidal wave of information with regard to the mitigation evidence. So, and it revealed his childhood was marked with neglect and is filled with negligence and abuse. He was born in a neighborhood where there's frequent shootings and drug overdoses and gang fights. That his mother had she had 5 children. The second of her 5 children, him, was born when she was 17. The children's fathers never stayed as part of the family. It was just such a disgusting mess that this guy had been through, and it was so. None of this came up during the original trial, so you could have went through his whole background here. There were 2 experts that were brought up in this, although one of them wasn't called, I think. They also brought up the fact that he actually, while he was waiting trial, tried to commit suicide, tried to slash his wrists. There's just so much to this of how bad this guy screwed up.
I mean, I just to point out, I looked up the attorney's name. He apparently died last year, so disbarment not necessary.
I was just trying to see if there was more.
He was a former prosecutor too. That doesn't surprise me.
Basically, the habeas court wanted to grant the petition, and then the Texas Court of Criminal Appeals rejected the trial court's recommendation for a grant of habeas relief, and concluded without elaboration that he failed to meet his burden under Strickland in Washington, which was Strickland v. Washington is the current case that establishes the standard for determining when a criminal defendant's Sixth Amendment right as counsel has been violated due to his attorney's inadequate performance. And you need to establish beyond a preponderance of the evidence that the counsel's performance fell below an objective standard of reasonableness, and that the performance gives rise to a reasonable probability that if counsel had performed adequately, the result would have been different.
Now, I think we should clarify for people. This does not mean that what was it? His name was Andrus, wasn't it?
Andrus, yeah.
Yeah, Andrus is not now free and clear. He's probably going to get a new trial.
Yeah.
Probably going to find him guilty. And there's still a good chance they're going to kill him. But
yeah,
you've bought some time at the very least. I mean, it's entirely possible if the outcome is the same, even with a competent attorney, frankly, given the facts of the case.
Yeah,
but we will see.
Well, I mean, if you could argue, there's a lot that he could have probably argued that he screwed up on.
Again, Well, again, the point being, it's not so much that they like sentenced him to death. It's that his attorney didn't try.
Yeah.
Had his attorney tried and the outcome was the same, this would not have gone as far as it did. He would be on death row right now.
Yeah. Again, I think the major thing that they focus on here, as far as the Supreme Court, is that is whether the preponderance of the evidence that is whether they met the objection standard of reasonableness.
Clearly, he did not.
Well, the Supreme Court here says that they didn't take this into account. That the lower court screwed up on this. Gorsuch and Alito and Thomas joined in the dissent. So
not surprised by that.
And they mentioned that according to the majority, it's unclear whether the Court of Criminal Appeals considered Strickland's prejudice at all, right? Like whether they even they just went ahead and ruled on it, and they focus on that this is contradicted by the opinion which explicitly said that he failed to show prejudice. I think that's kind of a weird thing, right? They are saying, one side is saying that he failed to show prejudice, that the court failed to take it into account because they didn't really address it. I mean, like they just said, oh, he failed to show prejudice and not establish why, which is kind of weird because you're asking the court to address a negative, kind of answer a negative.
Yeah, that's odd.
But that's what the majority is saying, is that they didn't address it. They didn't say, well, this isn't enough. This isn't enough. This isn't enough. Whereas the dissenting opinion here is saying, that is actually specifically addressed, and that he failed to establish either both the objective standard of reasonableness and the reasonable probability that the result would have been different.
I will admit the fatalist in me understands what the dissent is saying of like, they're going to kill him anyway, may as well just let him do it now.
Well, I think that the dissent argument here is basically, if you're saying, oh, he did not.
Well, that's not the legal argument they're making, but like, read between the lines. That's what they're saying. It's like, it's not going to be any different. They did enough. The outcome will be the same if he did have a competent attorney, so whatever.
Well, yeah, that's part of the reasonable probability that the result of the proceedings would be different, right? They're saying that it won't be different.
And I can totally see that being the case.
Yeah.
That even they'll assign someone new to this, and the outcome will be pretty much the same. But I still think the majority got it right, though, because it just seems rather egregious to me how little this attorney tried.
Oh, and I think that's why he's getting a redo. I think that's the point. I think that's. I actually think Strickland's a little too much. I think Strickland's a little too harsh.
Yeah.
That second part of Strickland, which is the reasonable probability that the result of the proceedings would have been different. That is such a hard thing to determine without knowing more.
Again, this is why malpractice insurance for criminal defense attorneys is next to nothing. Is because good fucking luck proving that. Yeah, I would. I mean, in my perfect world, that wouldn't be part of Strickland, and it would just be you didn't even try. That's how I would view it. Because come on, man, you have to make an attempt.
Yeah. So sad that I mean, I personally don't like death penalty cases anyway. But I mean, that's just a personal.
Once again, proud to be from New Jersey, a state where we don't have the death penalty.
Yeah, we got rid of it a long time ago.
Yeah, it was I want to say it was in the 70s, wasn't it? It's been a while.
New York, I think only recently got rid of it. Relatively recently.
Yeah, but the question is, when was the last time New York executed someone? There are states that have it, but they just don't use it.
It's expensive. It's a tough process. And honestly,
it's a pain
and also, I think a lot of states are moving away from it. Although Trump apparently put 3 cases for the death penalty for the federal, three federal cases up on to try to push him forward, which is weird. Like, I've never seen that from a president to try and push forward with 3 death penalty cases.
Because that's what his base wants.
They want to see people die.
Which is kind of crazy when you think about it, but whatever. I mean, I could be wrong. Maybe Trump's base doesn't want to see people die. Maybe the man's just a sociopath.
Clearly, I honestly think that's. I don't know, man. That was weird though when I saw that pop up this week that there was 3 cases that are all kind of looking for stays or trying to make sure that, because at least one of them was what's the phrase? It was a murder case, but what happened was he himself. It is a felony murder case.
I was gonna guess that, but I didn't want to be wrong.
Yeah. So yeah, it was
a felony murder rule. That I haven't heard of that for a while.
Well, there's a lot of cases. There's a lot of states that use the felony murder rule, and that is a big deal for them.
I don't think we have felony murder in New Jersey, right? I don't think we have that. Pretty sure we don't.
Yeah,
I've never come across it.
So basically, felony murder means that if you are in the process of a crime, and it usually includes a specific set of crimes in most states.
It has to be an inherently an inherently dangerous felony. Because there was that one case that you learned in crim law where the dude was committing tax fraud, which is a felony, and then someone died somehow, and they charged him with felony murder, and that's not really what that was for.
Yeah, so that case. I could
remember the name of that case. That was a good one.
Yeah, so under the model penal code, there was I think 5 or 6 of them that pop up specifically, and I think it's arson, burglary.
Yeah, if you're committing a non-violent felony, it doesn't apply.
Well, actually, maybe the original. I'm thinking maybe the original model penal code didn't include arson for some reason. I know it includes it, and New York had it. So yeah, it means that they were committing a crime. Somebody died, and actually, a lot of times, what a lot of these cases are, is somebody gets shot by you get into a shootout, and your partner shoots somebody, or the cops shoot somebody, or the car careens off the road, and then somebody died in the process of that, and then you are now guilty of, or at least potentially guilty of felony murder, which is, I think, kind of strange thing that was your intent was not to actually kill somebody, although I guess it depends on each individual circumstance.
I understand the mentality of you set out to commit a serious crime, and in the facilitation of that crime someone died, and but for your committing that crime that person died, and so you indirect. I mean, but isn't that just sounds like manslaughter to me? It's
well,
you
honestly,
didn't really intend. It just happened.
Yeah, and in fact, I think in that one case that I'm referring to, as far as I think the state themselves didn't move forward with such a case for him, because they themselves could have tried him, and I think the federal government decided to try him instead. But they didn't want to apply the felony murder rule to him.
Oh, I am wrong. New Jersey does have the felony murder rule.
Really?
In fact, it looks like a majority of states have it.
It's from common law. So
my guess is this: most states have it, but many states just don't use it.
Yeah, and there might be some states that have pulled back on it.
Yeah, I'm sure it.
I think arson's a big one where they'll keep the felony murder rule in place no matter what, because if you're burning down a building and somebody dies, you set the fire, that's a potential risk.
Yeah, but could you just call that manslaughter? That doesn't have to be. Do you really need a separate thing though? I mean, I guess if you want to punish them more harshly and call it murder, I guess.
Well, in some respect, it could be second-degree murder, right? You are in some states where you are saying you are acting with such reckless disregard for human life.
And while I am on the Wikipedia page, bear in mind this is Wikipedia, I could be wrong. The Model Penal Code lists robbery, rape, forcible, deviant sexual intercourse, arson, and burglary, and felonious escape.
Oh, if you're escaping from prison and kill somebody.
Yeah, if you go on a high-speed chase, I guess. And you crasher. Although, strangely enough, high-speed chases, like the cops tend to be the ones that kill people, not so much the actual person. How many
Yeah,
times do you hear like, "Oh, we went on a high-speed chase, and like we crashed a cruiser into like a minivan"?
man, it's Thursday we'll get more cases coming out.
Yeah, they're probably not going to be as interesting though. We got the big one.
The big fish of it all. I don't know. I'm intrigued. I have to look at what's coming
I
down
you know
the.
I feel like there was another interesting one. I just don't remember. It's been a while. I remember looking at like the docket back in like February, which feels like forever ago. And
Well, yeah,
then
after
I just and then I
Chronopocalypse,
just stopped caring. And I was like, "Oh yeah, it's coming up soon."
the new cases that they're. I know they announced 3 cases, that they are going to take, and they asked the federal government to submit in the Texas versus California case to submit a brief. So,
Hmm.
and that case has to do with California wants to limit their government officials being able to use state money to go across state lines to, like, say like you're in California and you're a state official. They don't they're basically limiting you from using state money to go to Texas for like a seminar.
Just is there
For
a,
for the
is there enough
the
money on
reason
the line for California for them to give a shit?
on the basis of the reason why they wrote this law is it has to do with sanctuary cities again. It keeps on coming up with
Oh,
all the immigration stuff.
that makes sense. I was gonna say I feel like that's not enough money for California to really care, but when you put it that way, I can kind of see why they might care.
Yeah, it has to do with because the law doesn't specify Texas. It says any state. Like basically, state officials can't use state funds to go to a state that is has anti. I don't remember what the actual. It has to do with the immigration laws though.
Hmm.
So that's one that they're going to take up for. I guess they're going to start hearing oral arguments on eventually, or they're going to.
Interesting.
And they had 2 more that they listed for oral arguments coming up. So that's but that's the bulk of this week's stuff, at least as far as what we've had so far.
I mean, it's all the interesting stuff.
Yeah. Thank you for tuning in. Thank you for listening. That was kind of fun. Again, if you want, you can follow the podcast at PUNK Law 101 on Twitter, on Instagram, also on Facebook. You can follow me at BROJO, Death is in the End of Life, Punch, like that delicious drink you drink in the summer. And I also do a football podcast. You can check that out. It's called Draft Vice. We talk about football and draft things and stuff like that. So if you're into that shit, check it out. Squeeze me. And tune in next week. We're working on some new intriguing episodes. We're gonna have a guest on coming up soon, hopefully. And take care. TTFN. Ta-ta for now. Bye-bye-bye.